about 7 after now at this point, so we're gonna go ahead and just, people might trickle in, so if you can just make room, because nobody likes to sit in the front, so I'm sure they're gonna sit back with you guys. For those of you who I didn't get a chance to meet individually, my name is Carly Campbell. I actually work for Heritage Title. I'm their business development marketing manager, and I work with Keller Williams here in town, which is how they found me through Brittany. And but I work with Keller Williams across the whole state, but we can work with anyone. We're an agent of Investors Title. So my card is in the bag, the goodie bag. So if you want to check us out, we have a little barcode on there. It goes right to our website. We'd love to work with any of you guys. We are a great partner here in town, and definitely would love to work with you guys. And help yourself. The notebooks are great for taking notes today if you can bring a notebook. And there's pens in there too. So, and I also wanted to introduce our speaker today. So for those of you who haven't met Brittany, this is Brittany Moore. She's with Guzman Rose, Calvert and Kramer. I'm sure most of you guys know them. And Brittany joined them about 6 months ago, and she has been practicing law though for 10 years. She previously worked for Ron Moore here in town as an estate planning attorney. And she is a native of Asheville, and she attended Western for undergrad. And then she did her JD at the Charlotte School of Law. And so she's been in business, like I said, for 16 years doing estate planning services. She's a member of the North Carolina Bar, the 40th Judicial Bar Association, and the U.S. District Court for the Western District of North Carolina. And we also have, hopefully, Beth Kramer, who's one of the partners at Guzman Rose, who's also coming to answer more specific real estate questions that maybe might go over what our knowledge is. Hopefully she's gonna be here. Of course, school got out yesterday, so she had her girls with her. So we're hoping she can make it. And I'm here to answer your title questions, and I'm gonna have a few slides as well. But Brittany's gonna get us started, and we're gonna sort of just tag team back and forth, and we'll just do questions at the end. Is that okay? So write your questions down so you don't forget you have them, and then we'll take questions at the end. So thanks for being here.
Hi everyone, it's a pleasure to be here. Thanks for having me. Like Carla said, I'm Brittany Moore. I'm with Guzman Rose, Calvert and Kramer. I got to the firm in February, but I've been practicing for 10 years, but have been a legal assistant, receptionist, you name it, I've done it. So I am here. My bread and butter is in estate planning. I previously also did estate administration, and I also do real estate. So I'm in a real unique position to talk to you guys about today about issues that come up frequently when estates try and sell a property, and what to look out for so that you're better prepared to deal with those questions, any potential issues that are, well, I say potential, the issues that will arise when dealing with an estate who is your seller for a piece of property, and just kind of open that line of communication. If you ever have any questions and your seller is an estate, please don't hesitate to contact me. I'm more than happy to have that conversation with you, whether or not you use our firm for your closing or to represent your seller. So estate planning, what is it? So very basic. And please forgive me, but I like to start at the beginning to move forward. So if this is information you already have, I'll try and move through. If you do have a question or want me to get any more nuanced in the differences or answer any questions for you, like Carla said, please hold them for the end. I'll be happy to answer them for you. So a last will and testament, not a living will. That's an advance directive. So an estate planning attorney issue, that one's called a living will and one is a will, two different documents. But a last will and testament is a testamentary document that states what you want to have happen to your real property and your personal property after you pass. So you can dispose of real property and personal property, grandmother's brooch, any asset that you have via a will. There are 3 types of wills in recognized wills in North Carolina. You have an attested self-proving will. This is a will in writing, typed, not handwritten, typed writing that 2 witnesses watch you sign and state that this is your testamentary document. They provide a self-proving affidavit that is attached to that will. So when that will is probated, if there are any caveats or challenges to that will, those witnesses do not need to then subsequently be brought in to court to testify that the testator did in fact execute that document. These are the only wills that I deal in. The other type of will is a nuncupative will, and that is entirely in the testator's handwriting, in front of two witnesses and kept in their safe place where they keep their papers. And so if you are presented with someone's will and there is a note or a strike through or an initial where they've tried to amend a typewritten will, those handwritten changes will not be recognized. Same with the nuncupative. If there are some typed, some handwritten, it will not be recognized. It must be completely in the testator's handwriting. And then a holographic will is an oral or deathbed will, where someone in their final moments realizes they don't have testamentary documents in place and state they want to leave everything to their daughter. That's fine, except when it comes to real property. You cannot transfer real property according to a holographic will. It must either be attested or a nuncupative. It must be in writing to transfer real property. So why is having a will important? I'm sure we all have families, and while we love them, families are complicated. And so in order to prevent any type of misunderstanding or any type of discourse or argument between your family members, it's really important to make clear your wishes on who you want to inherit your things and how you want title to your real property to pass and who you want to inherit that property. And so now I'm going to turn it over to Miss Carla so she can talk to you more about what that looks like from an underwriting perspective.
And hey guys, if you don't mind, I broke a toe last week on vacation, so I'm just gonna sit here. I apologize.
Here's
So thank you. I appreciate it. It'll just make it easier. So and then also we're a small group, we can be a little bit more informal. So from a title insurance underwriting standpoint, there are some specific requirements that you guys will have to understand on a basic level, just because I get these phone calls every week, like, what do we need to do from a title perspective? So I wanted to weigh in a little bit on what those things are. And I apologize if this gets down into the weeds a little bit, but we're gonna make sure you guys get a copy of these handouts so that you have it. And I really just wanted to give this to you just so you know that there are specific things that we are gonna require. So if there's a will and you're transferring property using that will in North Carolina, there's a couple different scenarios. One, if someone dies with a will and the property that they own is in North Carolina, that will must be probated in North Carolina for them to be able to sell, okay? Secondly, if someone dies outside of North Carolina, and even if that will is probated in that state, but the individual separately also owns property in North Carolina, the will must then also be probated in North Carolina, which will probably make your clients very unhappy. So be prepared for that conversation. That's a very big takeaway from today. I get that call on the regular. So they think because they probated it there that they can just bring a document here saying that, and then they can be able to sell. Not the case. So third, if someone dies in North Carolina and owns property in multiple counties, the good news is that will only need to be probated in one county in North Carolina. So, but the executor, what they'll need to do is obtain a certified copy of the will and the order of probate from the county where the will was probated, and file those documents in the counties where the different properties that are owned are located. And so the reason why this is important is because that formal act of probate establishes the link in the chain of title from the deceased to the current owners, okay? And remember, very, very important, title does not pass under any will until it's been been probated by the clerk of the Superior Court in North Carolina. Okay, so that's the biggest takeaway from today. Okay, for that particular piece of it.
Do you want me to click through?
Oh, I can, yeah, that's fine. Thank you.
Oh, is that
Yeah,
their
no,
computer?
it's not. I'm
Okay.
sorry. Thank you.
No,
I
you're good.
forgot. Yeah. So, if you have an open estate that's going through probate right now, there's three main areas, that you have to focus on, or that we focus on in order to be able to underwrite that open estate. And those three are: which parties are necessary to convey title? Are all the debts paid, or will they be paid? And third, are there any inheritance taxes or estate taxes due, and whether or not they've been paid? So I'll break that down a little bit for you. So for number one, which parties are necessary to convey title? So I don't know if you guys know this, but if you've had your own will done, hopefully that someone's explained this to you. It's really important that that attorney include an express power to sell the real estate. It makes everyone's life significantly easier because there's a whole lot more that you have to go through if you don't have that. And that's what we're going to talk about here in a second. So, and if you ever have any questions about that, you can send the will over and Brittany can take a look and see if it's in there. Because you guys don't want to play an attorney and trying to figure that out for yourselves. So definitely send that over and she can let you know, because that's a big determining factor. So, and guys, we are going to send you the slides so you don't have to take pictures if you don't want to. I do that a lot and then never go back and look at them. So we'll definitely send a presentation. So if the will doesn't have that express power of sale clause, the real estate can still be sold. And there's two scenarios. So if it's been less than 2 years since the date of death, the heirs and the personal representative. So, and it's executor if there's a will, or administrator if there's not a will. And let me go back for 1 second. If there's an express sale, power of sale, you only need the personal representative.
Correct.
So, but if you do have that express power of sale, the personal representative can do it on their own. And because that's where it gets complicated, is you have to add those heirs in, and there's 15 of them, or God forbid 40 of them, and they don't like each other, it gets real fun. So, but if you don't have that and it's been less than 2 years, you need the heirs and the personal representative to convey the sale of the property. And it has to occur after the first publication of notice to creditors has run. It only has to be the first notice, but it has to have run. And that is the other thing that I always get a call about. That's, for some reason, that step gets missed. If that hasn't happened, nothing else can take place until that happens to sell that property. Okay. Unless it's been more than 2 years. If it's been more than 2 years, the heirs alone can sell the property. Okay.
And may I tack on to you there?
Please.
So, so that notice to creditors that she's referencing, that has to be run for 4 consecutive weeks in a local paper. So that's why she's saying after the first one has run is when the property can be listed. I always caution and recommend exercising caution and waiting until the notice to creditors has run that complete 4-week cycle, because what happens is, let's say you list it after week 1 has run, you still got 3 weeks left, but this decedent had all kinds of outstanding debt. You've listed this property. Now the debts exceed the value of the assets of the estate. So now you're going to be forced to sell that property to satisfy those debtors, those creditors against the estate. So the title company only requires 1 notice to be run. I always recommend exercising caution and waiting until all 4 of those run, and that window to file a claim against that estate is completely closed. Once those 4 have run, no other creditor can bring a claim against that estate. So you are free and clear, knowing all of the debts against that estate and what that is going to look like, and whether or not your property is going to be pulled into the estate to satisfy those debts. Go ahead.
Very good. So then that leads right into my next slide on open estates. Number 2, are all debts paid, or will they be paid? So for the purposes of ensuring the title, we want to know, to provide, so do you guys know that we issue what's called a title commitment to the attorney's office in order for them to be able to do the closing? And that's the precursor to the policy. And that's where all of these requirements that I'm talking about exist in this document. So a lot of people don't know that word, so I wanted to explain that really quickly. It's sort of our jargon that we use. So the title commitments, and I'll just call it title, but I call it a commitment, we issued as follows. So you won't have an exception to the debt if the following scenarios have occurred. If the estate is still open and the period for advertising to the creditors is not complete, but the attorney administering the estate gives an opinion on the sufficiency of the assets to cover the debts and the taxes, and or affirms that all the debts have been paid. So there won't be an exception if the attorney will make that statement, okay? But there will be an exception if the attorney is not able to provide an opinion or affirm that all the debts have been paid. And just specifically so you guys know, it's there, the verbiage underneath here in the italics is the actual verbiage of the exception that we're going to include in the title commitment. And it basically just says what I just told you guys, okay? So it'll either be with an exception, and the goal is to have a title commitment with as few as exceptions as possible, because your client would become liable for those debts if they buy the property, if we have to take exception to those things. So very important. You want to wait if you can and try to go for this without the exception. So, because most attorneys will want you to get to that point too. And then number 3 has to do, are the inheritance taxes or the estate taxes due? And so what here you need to figure out is, when did the death occur? And if you can help your client with all these details, they should have death certificates that show that. And then again, is there an estate in North Carolina? If not, is there a will that needs to be probated? And if the estate is, then figure out if the estate's open or closed. If it's open, the title company will choose the applicable estate requirement. And then if it's closed, the certifying attorney shows the heirs and devisees as the owners and makes no exception regarding the administration of the estate. And then no requirement regarding the estate is required at all. So that's just important. If the estate's still open, this is the last step in that 3-step process that we have to analyze. So, okay. So next we're going to go back to Brittany.
And just to tack on there a little bit, your closing attorney should be, excuse me, at GRCC, we will be helping you and your client through this process to make sure that we have everything that we need, and we work together to satisfy the requirements of the title company to make sure title passes free and clear, whether you're representing the seller or the buyer from an estate.
And so they do the title search, provide that to us, then we look at all the documentation they provide regarding all of these outstanding issues. And that includes looking at whatever wills are being probated and what's been recorded. And then that's how we create the commitment and send back to them. Okay.
Just don't want y'all to get freaked out and think that you have to go dig all this stuff up. That is our very great fortune to do that for you and with you. But so these are the things that you'll want to keep in mind when you're talking to a client that has an estate. These are some questions that you're going to want to answer right out front to make sure that you're not blindsided by some closing or some property that's listed on the market that now can't close for another 2 or 3 years because we have to iron out the estate portion of it. And so what happens if someone comes to you and they don't have a will? This is extra fun. It's called intestate succession or intestacy. And so this is the North Carolina statute. If you have a person that comes to you and says, well, I inherited this property from my father, but he was married to my stepmom, we don't get along, and she's got these other kids, there's a lot there that you're going to want to unpack. First of all, she does not have free inherited title to that property because he was married at the time of his death. So title to that property is going to vest in both of them 50-50. And so you're going to need something, since there is no will, The interest in both of them are going to be broken out like this. If there's a spouse only, the spouse inherits title to that property. If it's a spouse and one child, half and half. If it's a spouse and two or more children, biological children and or adopted children, or to be born children, then it's a third to the spouse, 2/3 to be divided equally among the number of children.
Is that regardless of the age of the children?
That is regardless of the age of the children. And so, but then what happens if, knock on wood, both husband and wife are in a car accident? There is no will. Who inherits what? North Carolina law states that there's a presumption of survivorship, that the decedent whose will or whose estate is trying to be administered is presumed to have survived their spouse. And so it gets really tricky. You're going to want to work with both estate administration attorneys for the deceased husband and spouse to figure out how title is going to pass and vest in either one of them and or their descendants or heirs. So as you can see, you're really going to want and hope for that your client or the seller of that property has a probated will or a testamentary document that is going to state how they want title to that property to pass. And so I'm going to turn it back over to Ms. Carla so she can talk to you about what that looks like from a commitment and underwriting standpoint.
So in that scenario, if the death occurred 2 years ago or sooner and there's no will, we're going to require the following. 1, proper opening of the estate. 2, the appointment of a personal representative, because if you don't have a will, you don't know who that is. And so the court will appoint someone. And then there needs to be an attorney certification of the first publication of that notice to the creditors. We're going to require the deed. The identification of all the heirs and spouses, which that's the part y'all sometimes get drawn into, unfortunately. And then we're also going to need the attorney certification or other evidence that the estate is not subject to federal estate tax, or if the estate is subject to federal estate tax, that they have or will be paid and there's money sufficient to do that. Okay. All right. So, next slide. Great. But if the decedent passes away more than 2 years ago but had no will, and there is a current open estate, here's what we require. 1, a deed from all the heirs and their spouses. So that gets really, really fun to try to track all those folks down. It can take months, and especially if they live all over the country, which people tend to do these days, or you have a fun where someone's in prison. Those are really fun.
Or overseas.
Overseas, yeah. I have done a closing before involving the Green Zone in Iraq. So it can be done, but it takes time. So you want a deed from all the heirs and their spouses. So that also gets really fun. Payment of any claims filed against the estate, and an attorney certification the estate is not subject to federal estate tax again, or if they have been paid or will be paid. So important note, if the estate was open prior to the expiration of the 2-year period following the death, and the notice to creditors was run during that period, the personal representative is also required to sign if the estate is still open. So that's just a caveat. It's all about these dates. So important to keep track of when and what happened. And then the next scenario, next slide, is that the decedent has passed away and this occurred more than 2 years ago and there's no will. We also require recorded heirship affidavits from 2 disinterested parties. And I'll let you, and then let me do these 3, and then we're going to go back to heirship affidavits for a second. A deed for the identified heirs and spouses, and again, that attorney certification about the federal estate taxes. So can you give them a definition and explain the heirship affidavit?
Yes. So an heirship affidavit is where a neighbor, someone outside of the lineal line, a next of kin succession from a decedent. So a neighbor, boss, someone who is not going to have any interest in the property or any inheritance interest, marital or otherwise, state that the decedent was known to them while they were alive, that these are the known heirs to the best of their recollection. And so what that's going to do, it takes a person known to the decedent and that the decedent was known to. So it's not your mailman that was just, hey, bye. It's got to be someone who has personal knowledge of the decedent and of the decedent's family lineage and who the next of kin are, to state in an affidavit notarized that these are the only known people to them that would stand to inherit the property under intestate laws or intestate succession, since there is no will to state who they want to inherit that. So if you, that will be something that we also ask you and the client to assist us with in identifying who would be a proper person to execute that heirship affidavit on behalf of the heirs.
Yeah. So if grandma has a neighbor who's lived next to her for the last 50 years, like she's a really good candidate. You know, those are the type of people you want to look for. And back in the day, we always had those neighbors because we lived in our places for a long time. It's harder now these days when people move around to find that kind of person, especially when it's someone who's not related. So it can get a little bit tricky, but that really helps us as the underwriter to feel good about being able to underwrite something that doesn't have a will. Because the last thing that you want is having, somebody missed an heir, or they were like, well, we don't know where this person is. And so they've kind of forgotten about a family member, or they pretend that someone's dead. I love how families do that.
It happens more than you think.
It happens more than you think. Well, she's dead to us. That's what we hear on a regular basis.
Yeah.
Well, that's nice,
But she's not dead and
But
we
she's
still
not
need
dead.
her.
Yes,
Thanks.
exactly. I mean, you got to look for that death certificate and it doesn't exist because she's not really dead. So
And now I get mad because I've spent 5 hours of my time hunting for a dead person that is not dead.
that's right. So super important.
It has happened
Yes,
more than
it
I
is.
would care to admit.
Yes. And the next slide. Yeah.
Actually, it is very similar to that. There's a little bit of a fluff and a softness bit to it, but can you, I really present that question is, can you provide me with a copy of their birth certificate? Well, she's dead to us. Okay, well then that's a different conversation. Let's have that one.
And so if we are not able to have these requirements met, the policy, the commitment and the final policy are going to include an exception for the claims of heirs and creditors of this estate, and basically just says this policy does not insure against the rights of any outstanding heirs of whatever their names are. So the person who's deceased. So if we can't get that, we can't ensure that someone's not going to come back. So very important that we get those. So your new buyer is taking title clear of those exceptions. All right. Now we're going to switch gears and head to trusts.
Yep. So trust is also a testamentary document on how you want your real property and your personal property to pass to those named individuals in that document. The main difference between a trust and a will is a trust is not subject to the purview and oversight of the court. It does not have to go through probate. There is a small exception to that, and we will get to that, but the document itself achieves the exact same thing that a will does. It states what your wishes are, who you wish to inherit, what specific things, who you wish to take title to property, how they are going to do that, if there are any restrictions to that, say there's a minor in the will, how that's going to be handled for them. You can be very basic with these, or you can get very, very complicated. We call it the alphabet soup of trust. It covers a bunch of different IRS exceptions and how you want to take care of your spousal share. It gets very into the weeds very, very quickly. I do very complicated trust documents as well as very basic ones. I tailor them to my clients and what their assets are and what their needs are. But there are two main types of trust. You have revocable, which is done during your lifetime. You are both the grantor and the trustee, so you have full authority to add, change, sell, liquidate, completely rid the trust of any, we call it corpus or assets of the trust, and essentially make it a shell company. And there's nothing for it to manage, so it really has no operational function. I advise my clients against that, but it does state their wishes. An irrevocable trust means that you're the grantor. You can also be the trustee, but if it is irrevocable, you have a much more restricted ability to add, change, sell the assets of the estate. You also have very limited ability to change the trustee, change the beneficiaries. There's a lot more restrictions. The benefit of an irrevocable trust is really mainly for my older generation who are worried about the 5-year Medicare, Medicaid look back period in the event that they need assisted living or some advanced type of medical care. It'll protect the trust assets for the benefit of those beneficiaries from being clawed into or subject to a claim of lien or subject to sale from Medicare, Medicaid. So that's really where I use irrevocable. I start all of my clients out with revocable because it gives you the freedom to move and change and add and subtract the way that life does while you're alive, or until a situation happens where you want to, metaphorically speaking, put your wishes set in stone. And so it's a one-way street. You can start out revocable and move and change it to an irrevocable. Once it is irrevocable, you cannot go back. The only way to dissolve or terminate an irrevocable trust is by consent of all of the beneficiaries named in that trust. So, if the assets have been removed from the trust corpus prior to making it irrevocable, there's nothing for the trust to manage. There's nothing for you to change. That is one way for a trust to dissolve, but it does not actually terminate. The entity is still there. It just doesn't have anything to manage. So why is having a trust important? For those of us who have extremely complicated family lives, there's step parents, step children, divorces, multiple marriages, adoptions, things like that. In order to minimize any family discourse or arguments over and fights over what they think they're entitled to from you, similar with a will, put your wishes in writing. These are your things. And to minimize any fight or discourse between anybody else because of what they want or what they think they're entitled to, put your wishes in writing, because then it is unequivocal what you wanted and what the trustees' responsibilities are in distributing those assets according to your terms. Now, there will always be caveats. That's a whole nother lecture day. And so I'm going to turn it back over to Ms. Carla about what that looks like from an underwriting perspective.
Yeah, so important, the last thing that was on that slide is why is the trust important? Again, it avoids the estate then avoids probate. I mean, that's one of the big reasons, in addition to all the other things that a trust can do for you from a tax perspective. One of the main people really want their privacy these days because everything it seems to be a matter of public record. And if you don't want the whole world knowing about your finances, having a trust that doesn't have to be probated is very important when the person who you're trying to protect does.
And can I pause you right there? So a trust itself doesn't have to be probated, but part of my trust package is what we call a pour over will. And it's essentially a shell document, a shell vehicle to be presented to probate, to run specifically to run that notice to creditors, to remove any claims against the decedent's estate. It's a 3-month process. Bing, bang, boom, run the notice to creditors, done. All of your assets and their valuations and everything like that is now, like Carla said, not public record. And once that notice to creditors is run using that pour over will, I incorporate by reference. I don't state any of your things except who your beneficiaries are, who your trustee is, who your executor is. They have the authority for power of sale, and they have the authority to receive any claims of credit or claims of debt against the estate, resolve them, done. And that is, so it's a very, very much smaller court involvement and oversight than a probation of a will is.
Yeah.
So thank you for
Thanks,
letting me
Mary.
throw that
Yeah,
in there.
No, yeah, I'm glad you did. So it's very important. So what we need to underwrite that trust is super simple. One, we need certification by the attorney as to the existence of the trust. And usually there's a trust certificate in the trust documents that we can use for that. Most highly thought after estate planning attorneys now include that document so that your client can just pull that one piece out and provide that. They will also need to provide to the attorneys, and then he will provide to us the identity of the trustee and the trustee's authority to then enter into a real estate transaction and then execute all the documents, including the deeds, the deed of trust, et cetera. So that's very important because we need to know who we're dealing with and who can act. And then when there also is a requirement, and I don't even want to say that the trust needs to be recorded because we really don't do that anymore. There's just a memorandum of trust that is usually required to be recorded that basically outlines the real estate provisions in the trust and the authority of the trustees to act. So we make it really simple. Don't scare your clients into thinking they're going to have to cough up their whole trust and that it's going to be recorded and become a matter of public record. So as long as we can meet those requirements, if those requirements are not met, then we will have an exception on the policy that says that we do not insure against loss or damage resulting from the unmarketability of the title, which means you can't sell it, due to the questions about the trust or the trustee's authority to act. Okay, so back to you.
Okay, so another way estate planning will pop up is you have a buyer or you have a seller who does hold 100% ownership and title of that property, but it's subject to a life estate, which means that someone is allowed to live in and occupy that property for the duration of their life. Or until they vacate or willfully relinquish that life estate. It is not transferable. So if I grant Miss Carla a life estate in my home, her kids don't get to tack onto that. If she has to, knock on wood, not wishing this for you, if she has to move out of the home so she can get specialized care at a care facility and will not be returning to the home, she has relinquished her life estate. So that's how that's going to look like. Or it could be a standard contract. I don't want to live here anymore. I'm out. So the property cannot be sold while a person has a vested life estate interest, except or unless the person holding that life estate consents to that sale. And that sale would be subject to that life estate. You cannot kick her out. The new buyer cannot kick her out, him or her. The person who inherits the property after the life tenant passes away, once that life estate terminates, then you can sell the property or buy the property without being subject to that life estate. So it's not going to be any kind of testamentary vehicle. It will be established that way. And like if a decedent passes away and he states in his will that the house goes to his son, but his current wife is given a life estate in that property, that's how that's going to kind of come up in the context of an estate. Of course, you can grant somebody a life estate without passing away, but in the context of an estate planning or an estate as a seller, that's how that life estate is going to pop up. Somebody has stated the property, it belongs to someone else, but they're reserving a life estate for the benefit of a third party.
And you do see it a lot in the scenario, like if your dad got remarried and he has a wife, but he really wants the property to go to one of his children or both of his children or whatever, you know, a lot of times that second wife will have that life estate. So you do still see them. It's a little bit more rare than it used to be, but in those kind of scenarios, it can happen anyway, but that's a good example from what you might see.
You can also see this in an intestate situation. If you're married or once you get married, your spouse automatically gets a marital interest in everything that you own, especially real estate. And so if you die without a will, the state of North Carolina outright states that they are entitled to a spousal or elective share. And so that'll be calculated based off of what we previously talked about, sole spouse, spouse plus one kid, spouse plus multiple kids. But in addition to that, the state of North Carolina allows a spouse to either inherit their full portion according to that statute, or they can elect to have their spousal share be distributed to them as a 1-year spousal allowance plus a life estate in the real property. So that's also how you may see this come up. Or a family settlement agreement. There's a bunch of different ways. So that's why I wanted to make sure that we touched on this, because you can't just kick them out, and your buyer needs to know that if there is a life estate, you're absolutely welcome to purchase the property, but you can't inhabit it until she is gone. He or she is gone. So we've already touched on probate, but what does that really look like? So in order to probate an estate, you have to have a death certificate and a will, and it's probated in the county where the decedent lived or owns property at the time of their death. And so you have to identify the beneficiaries, notify them that the decedent has passed. You have to file what's called a 90-day inventory. It's a summary identification of the assets of that decedent's estate. You must run the notice to creditors to identify any outstanding debts from the decedent, close that period, and then you're able to really sell that property, knowing that everything that's going to shake out against that estate is up in front of you. Be aware that sometimes estates come with caveat proceedings or challenges to the will, so that may cause some delays. So don't think just because these things have happened that you are free and clear. Other things happen during the administration of an estate. Property to be sold to satisfy the creditor. So we've already touched on that. Real property generally passes outside of probate to the next of kin. But if the if the assets of the estate are not enough to satisfy those claims against the estate, the real property can be brought in, forced to sell to satisfy those claims. And how can probate affect the buying and selling of property? Be very flexible in your timelines. It is not going to be like a normal, I say normal, of course, we all know there's caveats to that, but it's not going to be a standard residential and or commercial transaction where do the contract, you do the earnest money due diligence, you have these set periods. They need to be flexible, and your clients also need to be aware of that they are not, so that they're not caught off guard if there is a caveat, or if some other error is identified, or if some issue pops up and closing is delayed. They're not chewing you out or chewing us out or chewing the title company out to keep closing on schedule, because we cannot legally until all of these things are met. So be flexible with your time periods and your estimations of closing, open communication, and keep them aware of what we are doing. Of course, we will as well, but this will also help insulate you from some unrealistic expectations when you're dealing with an estate. So I know we are approaching time. I had a whole thing planned for our case study, so you'll be less mad at me after this. So we are going to meet Mary. Mary comes to you and she says that she's inherited a piece of property from her dad and she wants to sell, and it's 15 acres. You're like, great, awesome commission. Here we go. What questions should you ask? Any takers? There we go. I gave you a softball there. What other ones should we ask?
Can I see a copy of the death certificate?
Bingo. Anybody else?
Yeah, siblings?
Boom. What's another one?
Was he remarried?
Attorney, is it in probate?
Wonderful, wonderful. Thank you for participating. All of those. You want to ask every single one of those, as well as, did her dad have siblings? And how did he inherit the property, or how did he get title to the property? Do you have a copy of the original deed? These are gonna, or, where, obviously, if you're gonna ask what county it is in. And so you're gonna also want to, if they can't present you with a will, they must present you with that death certificate. If they can't present you with that will, then tell me a little bit about your family. Tell me a little bit about your dad.
It wouldn't be different than a trust, and trust.
Yes, so if it was in a trust, there is a document, and you will want to, at minimum, get the trust certification stating that Mary is the trustee of Joe's trust. And if she cannot present that to you, it's kind of like an LLC. If she cannot present that document to you, she does not have authority to act on behalf of the trust. Don't take that listing. You open yourself up to a world of problems if you list a property on behalf of a trust without a trust certification. I will likely ask them for a copy of that trust to make sure that what they are claiming is in fact true, and that there's no kind of weird or hinky language, because I can write a trust any way I want. And so they're not one size fits all. Neither are wills, but they're they're more standard than trusts are. Trusts are all over the place. So I will want to see a copy of it. They may not provide it to you, but the bare minimum, you are going to want to see that trust certification stating that they have the authority to act on behalf of that trust.
So that's Mary Small before you started asking all these questions.
Uh-huh.
That's her small before. we
Yeah.
started asking all these
Yeah. And that's also before you start to metaphorically wrap your hands around the throat, because we're really gonna not like Mary by the end of this. So, her dad, Joe, inherited the property from his father, Dwight. Tell me a little bit about that. Did Dwight have a will? Nope. Joe had 5 brothers and sisters living at the time Dwight passed. So before Mary gets the property, there's 5 people who hold title to this property. So does she own the property? No. You cannot sell it with Mary's signature alone. If you do, your buyers are going to come after you. Or if you buy a property from Mary, you're going to want to come after her. So who needs to sign your Form 2T? Oh. So I inadvertently, this is going to be a little disjointed. I inadvertently deleted the connecting slide here. So Harry is one of Joe's brothers. He is deceased now, and he has 3 living children, but one of them is deceased with 2 children. Roy, another brother, is also deceased, who has 2 children, and his probate is still open. Joe, Mary's dad, is deceased. She is his only child. Will, her uncle, is still living, and he doesn't have any children. And her aunt Wilma is deceased with 2 children. So who has to sign this? Sign your Form 2T?
Lots of
Everybody, absolutely everybody, and then some. Also give a blood sample and your next born. So here we are. Who owns the property? Harry's 2 children and his 2 grandchildren. So there's 4. Roy's 2 children. But remember the open estate. So you're going to want to make sure that we've gotten through the probate process enough that the notice to creditors has been run at least 1 week. I recommend 4. She only requires 1. Take that with and do with it as you want. Mary. So we've got 2, 4, 6, 7, 8. Will, her uncle, who's still living. And Wilma's 2 children. You have 10 sellers for this property. told you weren't gonna like Wilma when she came in flashing this big commission at you for 15 acres, and now you've got to deal with all of this. So, yeah, so so it's really important for you to ask these questions up front so that you know what you're dealing with and you're not caught off guard and ready to murder Mary by the time we get involved.
And if one of those 10 people hold out,
Then you can't close. They have to go to court and have a hearing to do a family settlement agreement to either buy out the person who's holding out, or have a court order that the property must be sold in order to, or it must be sold. There's many different ways that family settlement agreement can shake out. But if you have one holdout, you're not going to be able to sell this property, and your buyers are either going to be able to walk away, or if they really want the property for whatever reason, make sure it's clear that that can take at least 2 years. And sometimes it's shorter, depending on how skillful your attorney negotiators are for that litigation portion of it. But if there is a holdout, you cannot sell, because all 10 of those people's signatures are required to transfer full title, clear and free to your buyer.
if there's 5 and 5, does that change the scenario at all, or 6 and?
They all, in order for full title to transfer, all 10 of them have to sign. Yeah.
But you still have to go to get a family settlement agreement.
Mhm. You have to, you would then likely at that point have to open a probate, have a hearing, get all kinds of attorneys involved. There's at least going to be 10 of them to represent each heir. You're going to have one representing the personal representative, whoever files first and is granted those letters of testamentary. And then you're going to have that hearing to determine whether or not, or you're likely going to enter into family settlement negotiation agreements to see if you can settle out of court. If not, then it goes to court. There's a hearing. Everybody has to appear. And so as you can see, it can get very, very complicated very, very quickly if you're not upfront with the questions and making sure that you're clear on all the parties that need to be involved in an estate.
There might even be a partition. I mean,
Yep.
half of it could be sold and the other owner, half could keep, the 5 could keep half and the other 5 could sell. So.
Yeah.
And did you have a
Yes.
question?
Can you comment on the proposed heirs act?
I am not familiar with that, so I don't have one right now. I will look into it and get back to you. Yes.
Is a living trust the same as a living estate?
So you have a living will, which is an advanced directive on whether or not you want life-sustaining support in the event that you are hospitalized and cannot communicate your wishes. A last will and testament and a living revocable trust are similar documents. The living trust, you can add, change, move it like we talked about while you're living. It becomes irrevocable once you pass. If you're married and there's a reciprocal will, half of it becomes irrevocable to the decedent's part of that trust. But a living will is not the same as a last will and testament or a living trust. So I really hate it when people call them living wills. They are advanced directives. You have a last will and testament, a living trust, and an advanced directive to keep all 3 of those separate. Yes. Oh, sorry.
First of all, what you just said a minute ago, I don't know if y'all listened, my head's gone.
Yeah.
So what Mary's going through.
Yeah.
And this is just what she only had a will, not a trust.
There was no will.
There was no will.
No will at all. So
Okay.
yeah, this is absolute nightmare, worst case scenario.
No will, not a trust.
Yeah, no testamentary document. This is how you figure out who your actual
And
sellers
her
are.
dad didn't have a will and his dad didn't have a
Yep.
will, so that makes them even worse, which
Right.
happens a lot with families in large pieces of property.
Especially here in the mountains. They just presume, well, my dad's dad passed away. It's mine. Yeah, I'm power of attorney, but there's no document.
Oh, no, I said part of the tree.
Oh, part of the tree. Yes. So sorry.
Or the oldest son or the oldest daughter.
Yeah.
Like, oh, I get it, because I'm, you know. that-
They follow Game of Thrones heritage rules. Like it gets really.
I know somebody who, worked with a guy, his dad passed away, so he went in and started fixing the house up, worked a long time, put a lot of money into that house. And then he reached out to another friend that's a realtor, said, I'm ready to sell my dad's house. That guy looked up, found out that his dad had given Will the house to the church.
Yeah, and you can, yeah, you've got to ask questions to make sure that you're not like WTF, like, what, no, what do I do now? And so back to, your, point is, this nightmare scenario comes in only if there are no wills or clear directives on how title to that property is to be passed. So it really illuminates why wills and trusts are really critically important for everyone. You don't have to be a millionaire to have one. I have a very simple basic one. If you have firearms and minors or special needs family members that you want to care for, or you're concerned about Medicare, Medicaid issues, now I can draft you a trust. It is very complicated and very nuanced, but I can draft that trust for you. I would recommend a trust for you rather than a will, because probating that's going to be a nightmare. If you have a second property that has, or second, third, fourth property that has rental income, I would want to put those in trust, and or an LLC. Since you are realtors, if you have your own business, one thing that a lot of people who have their own business don't think about is business succession planning. So for realtors, attorneys, doctors, anyone who has a special licensure to engage in that business, not everybody can come in and wind up your business. You have to name a professional licensed in your business to wind that up for you and assist the trustee in distributing and winding that up. If there's no one in your family who can take over that. Like when my father passed, he was an attorney. And to clarify, he was little Ron, not the former DA Ron Moore. So only an attorney could come into his practice to wind it up. Fortunately for him, that all fell on me, the whole lot of it. But so, you know, your children who aren't licensed realtors cannot come in and wind up your real estate business for you. We have to plan for that and what that's going to look like, and how you want those assets to be distributed. Pets do pet trusts. Wills are, and those can look a lot of different ways, but wills are very sufficient for some. They are wholly insufficient for others. And talking to an estate planning attorney who's knowledgeable in those two and what is going to best serve you and your beneficiaries is critically important. Nobody likes to talk about it. Nobody wants to face it. Everybody knows they need one, and nobody addresses it until it's almost too late, or now I can't do it at all because of competency issues. So if you have any questions about estate planning or know someone that could benefit from a discussion, I don't charge for a consultation. I'm happy to answer those questions because it is a very critical and vital piece to make sure that you have peace of mind, all of your things are taken care of, and you're minimizing any conflict or rupture in your family after your passing.
And Brittany, going back for just a second, one of the questions I get a lot is, how can we know what's going on? And people always call me and say, can you guys do a pre-title search before I list this property? Well, I don't do that because doing the title search is considered practice of law in North Carolina. So you need to engage a realtor, and it is highly recommended if it's going to be in a complicated estate.
A real estate
Or
agent. You said realtor.
Oh, did I say realtor? I'm sorry.
Yeah.
If you're but if you need that done or your
Mhm.
client needs that done, you just want to make sure that that it is done, because if you don't, I mean, you can just the pitfalls that you can run into, and it's definitely worth the money. And if
Yeah.
it's close enough to closing, you can apply the cost and
Right.
use that search. But I get that call on the regulars because they think because we're the title company, but in North Carolina, the title search is done by the attorney and they are, and they can be super complicated because a lot of times heirs don't really know. I mean, especially if it's in a complicated estate.
Mhm.
So, and people just assume. So do you want to do those quickly do those last
Yep.
few and we'll wrap up because we're a little bit over.
Yeah, so best practices, CYA, ask questions. Questions are your best friend to protect yourself. Be clear with the client and so that they understand what is happening and what needs to happen in order to either buy that property or sell that property from an estate. Step one, death certificate, will, letters of testamentary, notice to beneficiaries, notice to creditors. That process can take up to 6 months, depending on, how proficient and how efficient your executor or trustee is in making sure that these deadlines are met. And if there is no will, get a family photo or ask them for their family tree so that you can kind of gauge what that may look like or involve for you. And if you have any questions that you are not comfortable with, or that you think the client will benefit more from speaking with an attorney, please give us a call. I do real estate and estate planning. I'm the only one in our firm that does real estate and estate planning, but we have 6 other attorneys who do real estate all day, every day. So we are happy to answer your questions. So again, establish an open line of communication, obtain documentation, ask all of the questions. Don't presume to know the answer. Don't insert information. If there's a portion of this family tree or who may or may not be required in order to transfer title, give us a call. We are more than happy to help you figure that out and make sure that that's done properly and you have an enforceable contract to sell or buy that property. Please don't give legal advice. That's what we're here for. And we don't want to subject you to an unauthorized practice of law suit. That would not come for us anyway. Don't overlook red flags. If your gut is telling you something and you feel hinky about it, give us a call. Let's talk it through to make sure that something isn't being missed or you're not going to be bit in the rear later. And don't underestimate timing when it comes to estates. It is not going to follow a clean timeline. You can have a timeline in mind, but just know that it is subject to change pending any outstanding debts or claims against the estate. And so, any other questions?
I do.
Yeah.
So can you sell property even though the estate's open?
Yes,
Okay.
yes, you can do, and that happens frequently. In fact, if the estate is open and one of the only assets is that real property and there's a couple of different heirs, the only way the estate can be closed is once that property sells. I just finally closed an estate administration case that was open for 10 years to sell a 17 acre tract of land out in Arden. 10-year estate to sell this piece of property. So yes, please sell your property while the estate is open so we can close it up. There were other issues that came in there, but that's why you want to be clear about timing, that you don't have a set timeline. This is the anticipated, but note that it's subject to change, because I had a Duke coal ash problem with this property. There was access issues, there were air issues, there was a guardianship proceeding, there was a caveat proceeding, there was an eminent domain claim. I mean, you name it, this estate faced it. So that's why we were open for 10 years. So, and we got buyers on the hook and lost them repeatedly. Ideal piece of property, but what can you do? Sorry, you in the back. Yeah.
Yeah, I have a question. It's a scenario, actually. I listed a home and sold it. I was representing the heirs. There were federal liens. The the deceased was criminal and had federal liens, and the heirs knew there were liens, but didn't know the details, how much or whatever.
Mhm.
So that estate did pay off one lien. The house was being flipped. So when the flipper went to sell it, they uncovered the title and other lien.
Oh,
So
no.
how does that scenario happen, and then what happens to the, I think they finally worked it out, I went through the details, like what happens to the seller?
So the seller is responsible for resolving that outstanding lien before title transfers. If it was uncovered after title transferred, then the buyer's on the hook for it.
Whenever they sell it.
Mhm.
And so,
That is why it's very important for this notice to creditors to be run, and we require it. The buyer could go after the seller for indemnity. That's a whole nother thing, but if this secondary lien, or I say secondary, this additional lien came up after title had transferred from the original seller to the buyer, buyer is on the hook. And if title has not yet transferred, original seller is on the hook, but once that title transfers to that buyer is on the hook for that outstanding.
But doesn't it really depends though
Yeah.
on the date of when
Right.
that lien is recorded.
Mhm.
Because if that lien comes up after everything's finished, I mean, because there's no way, I mean, if you did a title search and it didn't really exist.
Yeah.
Then there's no, I mean, it's not gonna attach, it
my
had to
understanding
exist,
was it existed.
and they missed it, they missed it.
So then, yeah,
That's why you got title insurance.
that's why you've got title insurance, but I would go after the attorney who did the title search.
My understanding is that's what happened.
Mhm.
Well, that's when claims are paid.
Yeah.
The buyer, next seller did go back to
Yeah.
the attorney because my understanding was of this estate, there would not have been nearly enough money in the estate.
Which would have forced the property to sell to satisfy it.
And what happens if there's not enough? So you sell the property and there isn't enough money. There was nothing zero, but well, she died with $4 or anything else. So,
Oh,
but
boy.
there wasn't enough value in the house even to cover. these
Right.
things. So does that debt just go unpaid?
It's gonna transfer to the heirs. And what I've never encountered this situation. I've always found a way to zero balance out the estate. Whether that looks like a settlement negotiation, we just don't have the money to pay you. Will you accept whatever's remaining? That's a lot of the times how we will zero out the estate so that it doesn't transfer to the heirs, but so it can be resolved a couple of different ways, but that's the most common way that
So
that's gonna be resolved.
theoretically, If this second debt had been discovered and you couldn't have come before the heirs sold, and you couldn't have come to a settlement, they would have been responsible for their mother's criminal activity and debt.
Not her criminal activity.
Well, but the debt that.
But the debt,
She was an investment.
Well, and that is also something I would punt to a tax attorney to make sure, because the tax code and the succession and responsibility of federal tax debt is going to look much different than it is at the state level or any other other claims against the estate, say from hospital bills or a car accident or something like that. Federal tax law is going to really govern there. So I'd definitely punt that to a seasoned tax attorney to help you
Well,
figure.
It wasn't tax debt, it was just.
Embezzlement.
It was embezzlement.
Oh, okay. Then, yeah, that is an estate, this is why I don't do administration anymore. I do the planning.
And this is why people walk away from properties.
Right.
For things like this. I mean, people literally just will walk away and then no one owns it. So it gets really fun when that happens.
Yeah,
And you-
or if there's just so much conflict in the family, it just stays in the family and they just fight about it like the Hatfields and McCoys until the end of time.
But keep in mind that super important, IRS tax liens take super priority over the mortgages.
Yeah.
And those always have to get paid off first. So I have had situations where those were, I mean, there's multiple, I've had multiple, and they took up, luckily we had enough, but it basically took up everything.
So essentially, the heirs don't really get much.
Yeah.
Right.
This, yeah.
You
this-
go through-
This hadn't even gone to the heirs. The guy was just selling it. And because he knew that he was gonna have to pay them off, but he just wanted it. I mean, when you have IRS tax liens, you can't borrow money, you can't do anything. I mean, and a lot of times people will transfer property to other family members.
To try and
get away from
avoid.
those.
There is a look back period for
Yes,
that
there-
too.
So it gets pretty fun. So, yeah. Yeah. Oh, she has one more. Yeah.
Would title insurance have protected that buyer?
Yeah.
Yes.
Yeah, in that
So
scenario.
he could put a claim in and.
Yeah. and
But-
so-
Sorry, go
Yeah,
ahead,
but
Carla.
yeah, there's gonna be, but I mean, title insurance will cover it, but what we'll do as the title insurance company is we're gonna sue the attorney. If
Mhm.
they had a separate person do the title search, we're gonna sue them. We're gonna sue the seller because the seller knew and didn't say anything.
Yeah.
Cause at the closing table, they sign an affidavit as the seller saying, we don't have.
There's
any-"
no outstanding debt.
Yeah, that's not already been,
Yeah.
that's not laid out here to be taken care of today. And if they lie, they're liable.
Mhm.
So it's very important that your clients always get title insurance. And please don't have your clients say, I'm paying cash, I don't need title insurance. I'm like, that's the worst time to not get it.
Yeah.
Because then you're 100% liable without any protection from the lender's policy.
And we make you sign a waiver saying we have nothing to do with that. That was your choice.
And in North Carolina, there are very few attorneys now who will even do a closing if the
Without one.
buyer doesn't get title insurance. So just be aware, you have people moving here from other states and that's not necessarily the case other places. But in North Carolina, our attorneys are just not willing to take on the liability.
And to piggyback off of Carla, the dates of those liens are going to be critical on who is responsible for what at the time, before the time of closing, at closing and after. And who we're gonna go tag your it and say that you're responsible for that outstanding
My
debt.
seller knew that there were liens, but I don't think she knew how many or how much.
Then it's her responsibility to do that
She-
due diligence.
Yeah, she has to know, even if she
Yeah.
doesn't. She has
So how do you- I
responsibility.
mean, she was.
She
depending on
knew,
her-
she knew, she just didn't listen. She didn't take it in. When she went to court and she got held liable, all of those things, her attorney would have found out.
Yeah.
And she would have
No, I
known.
don't believe that's the case.
Well,
I don't believe that's the case. at
okay.
all.
I mean-
But she was depending on her attorney. I would not have chosen either attorney in this transaction.
Yeah.
Understood.
That's a whole nother.
Yeah, that's a whole
She
nother
should have
thing.
known. Let's
but-
put it like that.
Yeah, according to the law, she knew or should have known. And she was responsible for disclosing that, or her heirs were responsible for doing due diligence to uncover that and find that out.
Imagine, she embezzled that money from multiple different places.
She knew.
She
No,
knew.
she was dead. I'm talking about
Yeah.
the daughter.
Oh, well, her daughter can't, no, her daughter can't.
Right, no, no, I'm saying
Yeah,
her
the
daughter did not.
Yeah, that's different, yeah.
Well, daughter could have found out from her attorney
Yeah, yeah.
who represented deceased mom. She had a way to find that out and she just didn't.
Yeah.
Sorry, you had a question.
I heard you say a minute ago, Brittany, that irrevocable, you go from revocable to irrevocable at time of death.
Yes, so if you draft up a revocable trust, and to make it simple, we'll deal with a single individual and not a married couple and reciprocal and all this other stuff that can get into it. So we'll deal with a single individual. So you set up a revocable trust when you pass away, because you were the grantor, these were your wishes. There was no other grantor at the time you pass. No one else can change that document. So that's why it becomes irrevocable at the time of your death. Your trustee is locked in to the provisions and the responsibilities that you have lined out for them in your trust. And so at the time of your death, while it's revocable, it's attached to your social security number for tax purposes. At the time of your death, your trustee is responsible for getting an EIN from the IRS to identify your trust, to do business on behalf of that trust and not under your social security anymore.
So I have a revocable trust, my husband has one, for example,
Mhm.
I pass away, he's the trustee,
Mhm.
he has to follow all of these wishes that were in my trust.
Yep, he can't change, alter, amend it in any way. The only time he can change any term in your now irrevocable trust is if he's unwilling, unable, or cannot serve as the trustee. Then your successor trustee will serve. If one is not named, he does have the authority to name an individual to serve as your trustee. He cannot change beneficiaries unless a beneficiary has passed away or is let's say you have a firearms provision in your trust and the named beneficiary would be in violation of federal and local and state law by inheriting that firearm, he can change how your assets are distributed according to the terms of your trust, but it's very, very limited on what their powers
So
are.
that change happens automatically then from revocable to irrevocable? right?
Yes. Mhm. It is instantaneous at the time
So
of your
I was-
death.
I was blessed and fortunate and humbled 5 years ago, when my mom passed. I was the secondary trustee of that, and I had to sell 4 pieces of property in 5 different states. and touch
Bless your
part
heart.
of That, so I've got my hat on in a different position now, so I'm trying to unravel this.
Right.
With that, so.
Bless your heart. I know that was a lot. I know that was a lot.
One of the reasons why I got into real estate.
Yeah.
I did, this might be related or not. I have somebody who contacted me who is power of attorney for 2 adults in their 90s, parents in their 90s who are going to a nursing home.
Okay.
And I'm just curious that I should be asking a lot of the same questions
Yes.
if they're in their 90s. And how that pans out, that's power of attorney, if there be any conflict of any of these things.
Yes, so I would absolutely ask this person if her parents have any testamentary documents, a will, a trust, anything like that, just so you can get out ahead of it. She can do business on their behalf under a power of attorney while they are living. Once they pass, that becomes immediately unenforceable. And because the sole purpose of a power of attorney is to act on someone's behalf while they're living, if they're unable, incapable, or unwilling to do so. Once they have passed, there's no business to be done on their behalf. So that is why a power of attorney, also similar to the trust, is immediately terminated upon the death of the principal of that power of attorney. So let her know that if she is going to be buying, selling property on behalf of her parents under this power of attorney, it must happen while they are living. Otherwise, it needs to happen according to the testate or intestate rules of North Carolina.
So there's another thing, she said she needs it on the market by a certain date because the nursing home obviously is going to assume maybe so they become a creditor.
So that is touching on that 5-year look back period. If a person, see, it's really trying. It is really testing my patience today. There was a whole situation before everybody got here. Medicare and Medicaid, if you go into a nursing home and you don't have enough assets to cover the cost of your care and services that are rendered to you, Medicare and Medicaid can take a look back for a period of 5 years to take any or all assets or file a claim of lien on them to satisfy the outstanding debt for services that they have covered for your care, welfare, and while you're living. Generally speaking, it does not attach to your primary residence. If your equity in your primary residence is under $688,000. So if you have equity in your home that exceeds that, Medicare, Medicaid can look back and file a claim of lien against that property. Upon their death, they must be paid out before the property can be sold or transferred to anyone else.
Yeah, I don't know, they're still living, but
So-
that's my understanding that the nursing home needs this property on the market ASAP. And I'm thinking it's because they've left the state, like they're living in the state where the daughter's living, would that be
So wait, who needs the property on the market?
the nursing?
The nursing home. Big old red flag. There's some information missing there. They don't get to determine when a property goes on market or not. The only thing that they have an interest in is if it does go to market and they have an outstanding debt, they can file a claim of lien. They do not get to pressure anyone on putting a piece of property on the market. There's some information missing there, so I would do a little bit more digging. Yeah.
So if that was what we were talking about with the trusts, like if it is the property is in a trust, the Medicaid and they can't get to the money because it's in the trust.
Correct with caveats. So if there's a specific way we have to design that trust to protect that property and those assets from the Medicare look back period. So I would reach out to me and ask some more questions if you need some more information, because if it is not written properly, then no. If it is written properly, then yes, they're generally protected from that Medicare look back period. Yeah. Yes.
Question, you're talking about sellers, like helping sellers estate. What about buyers? Like, what are the best practices to help the buyers? Make sure we are, taking care of our buyers, like, what do we look for?
So, I thank you for asking that question. I spoke specifically about sellers for a purpose, because if you are representing a buyer who wants to purchase an estate property, you need to know what the seller needs to do in order for your buyer to get proper and
And you're
clean
probably
title.
gonna hope that the seller's done all of that.
Yeah.
Or at least 95% of it, because nobody has really any business listing a property if this work hasn't already been done. I mean, because you can't sell it. And
Right.
nobody's gonna sit around and wait unless they're just buying their dream property and they're not gonna build for 10 years, which is a very unusual situation, might happen here more than other places. But most of the time, you just want to make sure that for your buyer's protection, that there's not going to be some pitfall that comes up that hasn't already been taken care of. I mean, that's what I always
Yeah.
recommended.
Yeah, and so in representing a buyer, if they come to you and say, I love where this property is located, I've got all of these things, I want to do my own family compound, make sure that you walk them through, okay, absolutely fine to buy this property from the estate, but this is what you need to know that we need to look out for and prepare for. And we'll work with an attorney that makes sure that we walk all of this through and that the sellers are doing their part to pass marketable and insurable title to you that's free and clear of Joe's brothers and sisters or any outstanding debts or anything like that. So understanding how the seller side looks is going to give you an advantage in representing your buyer when purchasing from an estate.
So, Colleen asked about like if it's in the open estate, you can still sell it.
Mhm.
So why it's just a normal transactions if it's it's still in the open estate, and then you just go through the process of going on a contract, closing.
All of those requirements that I outlined in the beginning are just what we're going to require and need to know. So we'll be doing all of that in the background,
Okay.
but hopefully you need to find out from the listing agent where they are in the process.
Yes.
And until you can do that, before you even probably put an offer in, if there aren't details in the MLS that explain, the first phone call you're going to need to make is that, because I mean, you're gonna wanna know. I mean, hopefully you're gonna have a good listing agent who's done all those things and made sure her client has done all those things. Because most people aren't gonna waste your time and their time putting something on the market that's not really ready to be sold.
Right.
And I saw one of the slides says express power of sale.
Yes.
So that is basically like whoever is.
It's in the deed. It's in the will.
In the will or the trust, and it is nowadays it is pretty standard because
Yeah.
title companies yell at those attorneys who try to pretend like they know how to do estate planning. Everyone thinks it's just a copy paste. It gets very complicated, very nuanced, very quickly, just like real estate. But standard language nowadays in any testamentary document should be, and my executor and or trustee has the express authority to sell the property, to satisfy debts or distribute the proceeds to our beneficiaries. It is just automatically in every single one of my
So
documents.
the executor and the administrator is two different types of like hats.
Yes, so an executor or a personal representative are one and the same. They're named in your testamentary document. An administrator is the person the court appoints if that executor or personal representative is not upholding their fiduciary duty and needs to be replaced and removed from that post. Or an administrator is the person named by the court when there is no testamentary document. So they operate in the same function, but they do have a different title because there's a different way that they obtain that authority to act on the behalf of that estate.
So now the power of attorney and the express power of sales is two different things.
Two different things. The power of attorney allows you to act on behalf of another person as if you are that person. The express power of sale gives the person, after someone passes, the ability to sell their property for the benefit of beneficiaries. Does that make that a little bit clearer? We do like to interchange and overlap our words and mean like 1,000 different things. So it is really important to make certain that you're clear on what legal term of art that you're using to identify any
And if
portion.
you're sitting in this room and you don't have a package for yourself with a will and or a trust, a power of attorney, living will, and you operate a business, you need to make a phone call very quickly because it's
Hi.
very important that you guys have those documents to protect yourselves. And two, it helps you understand these things when you go to deal with your customers, because then you understand what you needed. Not everybody's gonna need the same thing, but the basics are the basics, and everybody's gonna need those basic things. And these days, with how complicated it is when people end up in the hospital and things like that, and you're having to make decisions for family members, you need to have all that stuff, your bases covered. So please, 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 don't assume that you're protected from a little basic will. Have all those.
Things
covered.
can go wrong very quickly.
Do you have to clear probate before selling?
No, yeah, no, you do not have to clear probate, like we were talking about.
Similar to the open the same.
Yep. You just, in order, if title to a property is titled in a decedent, someone who's passed, before that can transfer, at least down the line, let's say, like in my father's situation, it was him and me. I'm sole child, I get everything. There was a bunch of other things going on, but for this, father, daughter, boom, property's mine. But I don't have a deed on record saying that I have title to that property. I don't have to. Probate is closed. It is clear. Everything is mine. But when I go to sell that property, I will have to present the closed order from his estate stating that I am the sole beneficiary, that I have title to that property and title is vested in me and I am the authorized seller. I will have to present those if I go to sell that property. But while the estate is open,
It's just that notice of creditor.
yeah, that notice to creditors, you don't have to get through all of the other things. The buyer just can't take full title until if there's a caveat or a guardianship or whatever craziness can happen. They can't take title until all of that is resolved, but you can sell the property before all of that.
Can we just say you were gonna send these lines out?
Yes, Brian has copies of them. He's already been authorized to share it with anybody who asks.
Really well done.
Oh, thank you.
Very clear to understand that.
Yeah.
Great.
Good. I know it's a whole lot of information and there's a lot of if this, then that, and if not that, then this. So it does get very swimmy up here very, very quickly. And so, but we both wanted to make sure that we give you the basic principles and the basic questions and red flags that you're going to want to look out for to protect yourself, to prepare your client, and that also it doesn't come to our desk and we're cursing everyone like, why didn't you ask them if there was a will? And it just helps all of us work together in a more cohesive way to get that property from listing to closing in an efficient manner. You're welcome.
And my cards are, like I said, are in the bag, and you've got Brittany's cards. If you have
Yep.
questions, don't hesitate to reach out.